All right. Good morning, everyone. It's Friday. It's been a long week, and we want to welcome the audience. And before we get started, we want to thank our co-sponsors, the African Middle Eastern Leadership Project, the Renewed Democracy Initiative, and the Abrahamic House for their partnership in putting together this webinar. We are going to discuss today a very broad topic, which is what may be expected for immigration policy under the Trump administration. The format of this discussion is going to be as follows. I'm going to make some opening remarks, and then my partners, Patrick Terrell and Becky Young, are going to be covering a series of topics, including enforcement actions, humanitarian and asylum immigration, employment and investment-based immigration, and how, as well as family immigration, and how these may be impacted under the new administration. We are planning to offer frequent opportunities for questions, which should be asked using the chat function in the Zoom link. I do want to acknowledge any Grossman, Young, and Hammond clients that are attending. Please note that if you ask a question, it will not be confidential. Please also note that this session is not intended to constitute legal advice in any particular case or proceeding. Finally, just in terms of our goal here today, we aim to provide this audience with an overview of the major policy initiatives that we are expecting to see under the Trump administration. We look forward to providing you with insight and analysis into the potential legal challenges that the administration may face. We are not here to provide or promote any particular political perspective, and we'll be commenting solely on our area of expertise, which is U.S. immigration law. So to get started, as we've all seen, much of the news coverage today regarding the transition in government is focused on the topic of immigration and what is being termed as a potential overhaul of the Biden administration's existing policies. Just this week, President-elect Trump confirmed that he intended to declare a national emergency and use the military in some form to assist his plans of deporting a record number of undocumented people. A tremendous challenge that we have as immigration attorneys is how to digest and analyze this sort of fast-paced information that's coming out every day, and how to separate words from the administration's actual plans. The goal being to properly prepare and advise our clients on the coming changes. So at this point, we're really looking at three main sources of information in order to gain that insight. I'm going to touch upon these three sources briefly in this introduction. So the first sort of source that we look at is the experience that we had under the first Trump administration. During that time, we saw the implementation of a broad array of policies and initiatives that made it much more difficult, not only for unskilled labor and undocumented persons to come to the US, but also posed significant challenges for skilled labor and legal immigration. Just to highlight some of the main policies from the first administration, they introduced what was known as extreme vetting for certain visa applicants, which led to longer processing times at US consulates abroad, and led to a significant drop in the amount of persons that were admitted to the US. So just for context, the number of immigrant visas, so visas leading towards lawful permanent residency, issued in fiscal year 2020 dipped 45% from a year earlier. And the number of temporary non-immigrant visas, so visas like tourist visas and student visas, decreased 54% during that year. Nevertheless, we also have to take into account the impact of the COVID pandemic on visa processing, which certainly contributed to a slowdown in admissions. The first Trump administration certainly focused on border enforcement. They used an emergency health order known as Title 42 to basically seal the land borders with Canada and Mexico and to prevent immigrants from seeking asylum. There were then a broad variety of executive orders and policies to prevent and delay asylum applicants from entering the US. Again, for context, fiscal year 2019 witnessed the highest numbers of immigrant apprehensions at the US border since fiscal year 2007. The previous Trump administration also used executive orders, enacting nearly 500 of them, to dismantle much of the preceding US immigration system. So we saw very fast-paced changes in the field of immigration law, often barring whole groups of people from migrating to the US. Other than, and obviously there's a significant amount of other policy initiatives, but those are just some highlights. The second sort of source of information that we look at, other than what we experienced in the first Trump administration, is we're looking at Agenda 47 and Project 2025 to gain some additional insight into what we can expect this time. As most of you know, Project 2025 is a product of more than 400 conservative scholars and policy experts from around the country, and in some circles is being called the quote-unquote policy playbook for a second Trump administration. I will acknowledge that at times the Trump administration has distanced itself from Project 2025. That said, there are some clear links between his administration and their policy initiatives and the Project 2025 publication. Project 2025 has a focus on immigration policy and centralizing power in the federal government. Some of the immigration-focused proposals include terminating the legal status of over 500,000 Dreamers by eliminating staff time for reviewing and processing Dreamer applications. They will use backlog numbers within the visa processing system to automatically suspend large numbers of immigrant visa processing for legal immigration. There's also provisions in there barring US citizens from qualifying for federal housing subsidies if they live with anyone who is not a US citizen or lawful permanent resident. Like I mentioned before, Agenda 47, which directly lays out the Trump administration's policy priorities, parallel many of these initiatives. The agenda contains 20 core promises. I looked through them, and the top two address immigration, as well as Promise 10, which intends to stop the quote, migrant crime epidemic. Promise 1 is to seal the border and stop the quote, migrant invasion, and Promise 2 is to carry out the largest deportation operation in American history. So, and then very briefly to go over a few other policy initiatives that are laid out in Agenda 47. Some of the sort of highlights include ending citizenship by birth on day one through an executive order, and ending what they call quote unquote birth tourism. So citizenship in the US is a matter of federal law and is governed by the US Constitution and specifically the 14th Amendment. So we can explore the constitutionality of ending this right later on in the presentation. Other executive orders include implementation of what's known as the travel ban and pausing refugee admissions. Again, for context, during the first Trump administration, we saw a drop in refugee admissions from over 84,000 during President Obama's last year to 11,814 in 2020. And again, for context, the Biden administration set refugee admissions at 125,000. There are executive orders, again, dealing with border security and enforcement, reintroducing the concept of extreme vetting of foreign nationals, and blocking federal grants to sanctuary cities. As a reminder, a sanctuary city is not a legal term, but it's basically a community, town, city, state with a policy to discourage local law enforcement from reporting on the immigrant status of individuals unless their actions involve investigation of a serious crime. Many sanctuary cities refuse to deputize local law officers as federal agents, which would allow them to carry out the duties of ICE agents. Again, from a legal and constitutional standpoint, being an undocumented person in the United States is not actually a crime. It's a civil violation, which can result in a penalty, including deportation. So this is another topic we can revisit later on. There are other executive actions, suspending what the administration calls, quote unquote, chain migration, which is family-based immigration, ending the visa lottery, and all what they term non-essential foreign workers. Not finally, but another provision is the suspension of immigrants who are deemed to, quote unquote, financially burden the US healthcare system. So we saw some of this under Trump 1, which led to this correlation with extreme vetting, additional forms and questions about an impending immigrant's family, health status, and financial status at consular posts. There's also an executive order being promised to bring back Title 42. So those are just some highlights, but like under the first Trump administration, what we expect is heavy reliance on the use of executive orders to fulfill these promises. These orders are published in the Federal Register and have the force of law, but they do not require approval from the US Congress. So they can be passed much more quickly than, say, new legislation. And the president does indeed have broad legal authority to issue orders, like the ones that I just discussed, but a subsequent administration can fairly easily undo them, although the impact can certainly be long-lasting. So that's a lot to cover in just a few minutes, and I'm going to pass the floor to my esteemed colleagues right now so that they can dig a little bit further into some of these policies. And I will start with Patrick Terrell. Patrick?
And actually, quickly before Patrick starts, I just want to remind folks that we are happy to try to answer your questions throughout the presentation. So feel free to put them in the chat, and I'll be monitoring the chat, and we'll try to, to weave them into our discussion. So don't hesitate.
Well, good morning, everyone. Thanks, Sandra, and thanks, Becky. So for those of you I haven't met, my name is Patrick Terrell. I'm a partner at Grossman Young Hammond. I work closely with Sandra, who you probably know runs our international protection practice, which focuses on international human rights and fighting Interpol abuse, among other work. I myself focus on litigation, removal defense, asylum, other humanitarian immigration options, the nexus of criminal and immigration law, and a few other issue areas. My portion today is going to focus mostly on those topics. Sandra kind of covered some of the laundry list of sea changes that we're likely to see in various aspects of immigration law. I'm just going to do a little bit of a deeper dive onto some topics that I suspect may be of greater interest to this audience, but we're happy to answer questions in the chat about the things Sandra mentioned or anything else that might be on your mind. So the first topic I wanted to briefly mention is the Muslim ban or the travel ban. Travel ban is what the Trump administration called it. The Muslim ban is what critics called it. President-elect Trump has said that he's going to bring this back. He said he would invoke it to disallow refugee resettlement he specifically mentioned Gaza which he characterized as a hotbed of terrorism. The last travel ban or Muslim ban did survive legal challenges. It went all the way up to the Supreme Court in a case called Trump versus Hawaii, and the court allowed it to take effect. Which countries were included last time? Chad, Iran, Iraq, Libya, North Korea, Syria, Venezuela, Yemen, and Somalia. The ban prevented people from these countries from getting, in some cases, immigrant visas and certain non-immigrant visas, like H-1Bs and tourist visas and so on. Notably, green card holders were exempt and dual citizens were exempt. There was a waiver process within the travel ban where a person could show that they themselves were not a security threat, and that there were some compelling reasons that they should be admitted to the United States. But very few people were able to obtain waivers under this process. So that is the travel ban, and I'm happy to answer further questions about that. The next major topic, which is certainly in the news, is mass deportation and detentions. So Donald Trump has vowed to deport millions of undocumented immigrants. How is he proposing to accomplish this? He has vowed to use the military, and he proposes to declare a national emergency. I think this would be of questionable legality. He did something similar last time by declaring a national emergency at the southern border, and using government funds that had not been allocated for construction of a border wall to construct a border wall. It was enjoined, and to my knowledge, that declaration of national emergency never sort of had a final adjudication of its legality. And so there's still an open question about what the president's authority is to declare a national emergency when certain factual predicates are maybe absent. Remember, though, that under current law, people placed into removal proceedings are presumptively eligible. So let me back up. The way that I think the president, Donald Trump, is likely to use this executive order and this declaration of a national emergency would be to use the military to build large detention facilities to house immigrants whom the government is trying to remove. But remember that at least under current law, that people that are placed into removal proceedings are presumptively eligible to request release on bond from an immigration judge unless they pose a national security or public safety threat. And it has to be, it's defined in the statute what's going to qualify for so-called mandatory detention. Trump is proposing to enact this sort of deportation agenda through more what are called 287G agreements. These are agreements between federal authorities and local law enforcement, which basically deputize local law enforcement to enforce immigration law. One question that you might be wondering is it realistic to remove tens of millions of people? Not really under current law. Our system is not built for mass deportation. Removal is not an exercise of brute force. It's a legal process, right? People are entitled under current law to see a judge, except in certain circumstances where they can be removed without a judge. Our immigration courts are quite backlogged. There's a limited number of immigration judges. As of now, there's a limited amount of immigration detention capacity, right? Typically, on any given day, you'll have about 40,000 people that are housed in immigration detention, which is way shy of the hundreds of thousands, if not millions, that Donald Trump is proposing to remove. Could ICE remove a lot of people? Yes. Obama deported 2 million in 8 years. But the way that they're probably going to enact this is through greater use of detention, right? As I mentioned before, which results in kind of faster moving cases and people giving up in many frequently because they don't want to endure lengthy detention. And I think there's going to be much more expansive use of judge-free removal processes, which move much more quickly, right? There's so-called expedited removal, which allows people to be removed basically without going in front of a judge, so long as they meet certain criteria, they have not been here more than 2 years, or they're apprehended within a small distance of the border, and they have not been here for more than 2 years. There's another process called reinstatement of removal, which allows the government to deport somebody who's already been deported. They don't get to see a judge again. You know, the impediments that I mentioned to this agenda, ICE has limited capacity, right? There's only a certain number of ICE agents, immigration judges, there's a limited number of them. We have large backlogs, and we have, as Sandra mentioned, sanctuary jurisdictions that are not going to be, handing over information to ICE. So pressure is probably going to be brought to bear on those jurisdictions, but I think that those are some of the backstops that are going to reduce the president-elect's ability to enact that agenda. Denaturalization is another topic I just wanted to briefly touch on. I'm going to address this because it's in the news. There's a lot of concern about it, but in my
And we also have a question about it.
We do. Okay, I haven't seen that.
Basically, someone just is inquiring about what denaturalization might look like.
Okay, great. Well, so I think there's a lot of concern of this, but I do think it's likely overstated in terms of its impact. So denaturalization is the process by which a naturalized person is stripped of their citizenship. It is a judicial process. It has to go through a federal court by law. Historically, denaturalization has only been used in narrow circumstances when there was some really morally culpable conduct on the part of the person who's being denaturalized, right? For example, somebody was an actual Nazi, but lied about that on their immigration documents. Or somebody denied having committed any crimes for which they had not been arrested in their naturalization application, and then they subsequently plead guilty to a crime they committed before they applied for naturalization. If you look at the cases, that's when denaturalization happens. But the reason I don't think that this will be as impactful as perhaps the media suggests is because it requires extensive resources, often from DOJ, the Department of Justice, as well as the Department of Homeland Security. And this is why, when Trump was president before, there was a similarly announced kind of denaturalization initiative, but it didn't yield, substantial numbers of denaturalizations, hundreds, over the course of his term, not thousands or tens of thousands. The last thing I wanted to just touch on briefly is the public charge rule. Basically to get an immigrant visa or green card or certain other non-immigrant visas, a person can be barred if they are likely at any time to become a public charge. That's the language that Congress enacted, but Congress didn't define it. So it's been left to the agencies to define. And in the 1990s, the INS under Bill Clinton promulgated regulations that basically provided that a non-citizen who has become or likely will become primarily dependent on the government for subsistence, as demonstrated by either the receipt of public cash assistance for income maintenance or institutionalized for long-term care government expense, that is who satisfied the definition. So it's pretty narrow. It's cash assistance, right, or likely to be institutionalized at government expense. The Trump administration last time, interpreted the public charge language very expansively, and it would, basically cover the use of any means-tested public benefit, not just cash assistance, right, Medicare, Medicaid, et cetera, for more than 12 months in any 36-month period. And it basically replaced the sort of primarily dependent standard where you're getting 51% of your income in favor of a kind of absolute amount, not caring about the degree of dependency, right? So if you're taking any benefits in the 12-month period. So that was the sort of most dramatic change. It was blocked by courts during the pandemic. But there were often, and one of the things that I think we can all reasonably expect is, a flurry of executive action, as Sandra said, which is often more vulnerable to kind of injunction and court orders blocking them. But the courts have now seen and litigated a lot of these cases. What is old will be new again. You're going to see a lot of, these issues that have already percolated, get resolved by past precedents. And a lot of the policies, the reality is a lot of the policies that they announced last time were ultimately permitted to take effect. And so I think that the policies that we've been talking about, many of them, we will see basically become essentially, law in the United States. So let me hand it over to Becky to her
To
portion.
do some Q&A actually.
Sure.
So first of all, I didn't realize when I mentioned before the chat, we actually have a Q&A. So we're going to try to address, any questions that are in the chat. But if you folks could use the Q&A, that will make it easier for us going forward to have questions in one place. Some interesting questions. Maybe let's start with this one about gay marriage. So the question relates to, I guess, do you think that there's a possibility that the law legalizing gay marriage could be overturned? And then the question is, should gay international couples consider getting married right now in case gay marriage is repealed in the United States? So either Sandra or Patrick, do you have thoughts on that question?
I mean, I'm not especially worried about gay marriage being, sort of the right to gay marriage being overturned. I think it's possible, but that would take a Supreme Court decision. And I think that, the Supreme Court is rarely so far out of step with what the general public wants. And this would be an instance where I think the vast majority of people from polls that I've seen are supportive of the right to same-sex marriage. So that's my quick take on that. I don't know, Sandra, do you disagree?
No, I agree. And let's see, we've scoured Agenda 47 and Project 2025. I could be wrong. I do not recall seeing any sort of policy priority on the issue of gay marriage. The way that it could be affected is the way that I guess any marriage could be affected, which is the executive order that looks like it's going to be passed to end chain migration, which is really bringing in family members through the consular process or through adjusting here in the United States. So that's one way that all marriage-based petitions could be delayed.
Okay, thank you. Then there are two questions about LPRs with aggravated felony convictions. So one question, I'll read them both. Can the new government make changes to make it harder to get approval for waivers for aggravated felons in the adjustment of status context? And then someone else asked another question about, okay, maybe let's address that one while I find the other question about aggravated, but there are two questions about aggravated felons.
So the answer is yes, they can. How would they do that? They would, so getting a little bit into the weeds, the Attorney General of the United States oversees the Executive Office for Immigration Review, which is our immigration court system. And the Attorney General at any time can take a case, certify it to him or herself, and issue a ruling in the case that sets nationwide immigration policy. And we saw very aggressive use of that power in the first Trump administration. And we saw some use of that power in the Biden administration, largely to undo decisions of the Trump administration attorneys generals. And, the way they could make it harder to get relief is by issuing precedent decisions that deny relief, saying this doesn't meet the standard. And that sort of sets a guide for, who will be able to qualify for that relief. The Attorney General can't unilaterally change the language of the statute, right? And in some cases, courts have opined on, the meaning of these statutes, and the Attorney General won't be able to necessarily supersede that, although it's a little bit complicated on that particular issue. But that's how, you could see a kind of narrowing of who might qualify for those sorts of benefits. I mean, just to give you one example, there was a decision in the last administration that basically said that somebody was going to be presumptively ineligible to establish that they had good moral character, which is a requirement for certain kinds of immigration relief, if they had 3 DUIs, that was basically impossible to kind of overcome. And, that wasn't a rule before, right? But that just sort of narrowed the class of people who might be able to qualify for that particular benefit.
Patrick, I found the second question, which actually relates to someone who is an LPR with an aggravated felony. Do you think that the new government could bring an executive order to remove LPRs with aggravated felony without a judge, like expedited removal?
So they can't do that by executive fiat. LPRs are entitled to removal proceedings. There is a provision that allows ICE to remove somebody without taking them before a judge if they are not an LPR and they have an aggravated felony. But if you're an LPR, then you're entitled to process before a judge. So I think that's the answer to that question.
Okay.
Hopefully.
Then we have a question about SIJ, special immigrant juvenile status, and the EB4 category, VAWA and religious workers. I know from a conference I attended recently that the current actual wait in this category is 17 years. So it's already very, very backlogged. But so what's your opinion about how special immigrant juvenile status, VAWA, and religious workers might be impacted in the new administration?
I don't have any sophisticated thoughts on that question, Sandra. It's not sort of my, I don't do a lot on special immigrant juvenile status.
Yeah, I don't either, to be honest. I guess the only insight I would have there is I agree with Becky that it takes a long time to actually get any benefit pursuant to that status. And what we've been reading in the new policy initiatives is that it looks like there's going to be sort of a slowdown in the processing of any kind of visa petition. And I would imagine that when we're looking at these more sort of humanitarian-based petitions, there will be even more of a slowdown. And we did see this under the first Trump administration. Then I also think there could be an impact because of the public charge provisions as well. During Trump 1, there was an extensive, really tedious form that had to be completed in order to get an immigrant status that required lots of information showing that you had the financial health to stay in the United States. So I assume that those applications would be impacted by that as well. And I did see, Becky, there's another question from someone who's asking if they're from Iraq, Iran, or Yemen, and they entered the country legally, if they could, and they're in the US, if they can apply for being accepted as a refugee. And so just a distinction I want to point out there, refugee status is for people that are outside of the United States. Once you're, and as I mentioned during the opening, there's a significant drop in refugee admissions during Trump 1, and that's likely to be affected again. If you're in the United States already, you can apply for asylum before the U.S. Citizenship and Immigration Services. If you're in valid visa status, that's legally permissible. So you can still file before USCIS.
Okay, thank you. So we have a lot of, sorry, did you want to add something?
I was just going to say that the last travel ban did not impact people who were physically present in the United States and seeking asylum.
Okay, thank you. So we have a lot of lawyers on this call, so this is a very lawyerly question. And Patrick and Sandra, I'm sure you have some thoughts on this, but please, definitely there are a lot of non-lawyers on the call as well. So if we can make it as non-lawyerly as possible. So how does the Chevron doctrine being repealed impact immigration policy?
So the Chevron doctrine for non-lawyers basically says that when a law is ambiguous, the agency gets to fill that gap, right? So if, for example, Congress passes a law and they don't tell an agency how they're supposed to implement it, and the agency is sort of given some latitude to fill gaps, courts are supposed to defer to the reasonable interpretation of the agency. It's basically a doctrine that results in agencies, in plain terms, kind of getting affirmed very frequently when they change rules, when they issue decisions in cases. And what happened in the last term of the Supreme Court is that they overruled the case that called for that kind of presumptive, reflexive deference to administrative agencies. The changes, might be favorable for immigrants, where you might have interpretations of the immigration laws by the Board of Immigration Appeals. This is where we're mostly going to see this, I think, is going to be in the context of challenges to removal orders, but also in, challenges to new regulations that are announced and promulgated by U.S. Citizenship and Immigration Services. And, the agencies, they're just not going to get that sort of knee-jerk, you're probably right. It's going to be a closer scrutiny of, what does the language in the statute say? What did Congress intend? All the sort of tools of interpretation that are typically used to see whether or not the agency kind of got the law right according to the court. Instead of saying, well, the agency is reasonable and I wouldn't have interpreted it the same way, but I'm going to let them do what they want to do. You could have courts sort of second guessing agencies. And, for those who want to see a more generous immigration policy, I think, the death of Chevron may actually be a welcome piece of news in this second Trump term.
Yes, thank you. Okay, so we have a lot of questions. So Sandra and Patrick, feel free. Well, I'm going to turn to employment-based immigration for a little while. But feel free if you want to provide a written response to any of the questions in the Q&A section while I'm talking. We want to get as many questions answered as possible. So my name is Becky Young, and I run the employment-based side of our immigration law practice at Grossman Young and Hammond. And so we are definitely expecting many changes in the employment-based side of the practice as well. So most of the clients that we work with in the employment side of the practice have come to the U.S. legally, or they're outside the U.S. They want to come to the U.S. legally, and they follow a legal path through immigration. So most of what I'm talking about is what changes that will impact that population. So one theme that we've heard both in the prior Trump administration and also what we expect in the upcoming administration is the creation of a merits-based system. So revamping the immigration system to focus and allow only the most talented, highly skilled, highly paid individuals to come and work in and immigrate to the US through the employment-based process. So one visa that's been a big focus is the H-1B. That's the primary visa that is used for professional workers to come to the United States. Many of those workers are highly paid and highly skilled, but there's definitely a focus in transforming that into a more elite program to only bring the very top foreign workers at the highest wages. So for those of you who are familiar with the H-1B program, the U.S. Department of Labor takes wage surveys. So they survey the wages in different occupations and different geographic locations, and they report the wages at 4 different levels. So level 1 would be an entry level. Level 2 is just slightly above entry level, going all the way up to level 4, which is the most experienced. And there can be big discrepancies in the wages between those levels. So one of the proposals would be to preclude the use of level 1 and 2 wages for H-1B cases. And that would, practically speaking, probably eliminate the use of the H-1B for entry-level positions. So one of the most common routes for legal immigration in the United States is that someone might come to the US as a foreign student, particularly in STEM fields. Those individuals can receive work authorization after graduating from university, and then often their employer, will enter them into the H-1B lottery. And then if they work in the United States on the H-1B visa, they can then be sponsored for a green card. So that's a pretty common path. Excuse me. So that path would definitely be impacted if employers became unable to sponsor entry-level workers. A positive, at least from my perspective, would be increased opportunities for premium processing. So non-immigrant visa petitions at the Immigration Service are fee funded, so they do their work based on the fees that they receive. And premium processing is a program where you pay an extra fee of about $3,000 to get your case processed in as little as 3 weeks in some cases. And so that's available for most types of work visas, most types of I-140 or immigrant visa petitions that are employment-based, as well as some work authorizations, I-765, and extensions of stays for exchange visitors and F&M students. So it's limited to those categories, but they do want to increase the number of categories that can receive expedited processing, which is good news for those who can afford to pay for it, because the normal processing times can often be very long, sometimes over a year for different case types. So I think that would be a welcome change. The F and J categories, so this foreign student and the J exchange visitor categories are definitely of interest to the incoming administration. So there's a highlight on security, a concern about security issues for those students, particularly, and in Project 2025, the term enemy nations is used. Patrick identified before a list of countries that were subject to the Muslim ban. We can speculate that maybe some of those could be considered enemy nations. There is, in Project 2025, I think it's in the State Department section, a separate discussion of nations of concern, which are China, Russia, Venezuela, Iran, and North Korea. So I think that might also be, a separate list that could be of concern. So more vetting of foreign students and foreign exchange visitors. Another theme that we definitely expect to see is increased employer enforcement. We saw that during the prior administration, more robust investigations for visa fraud. So there are several different ways that employers can be investigated. Employers who file for benefits such as H-1B could be investigated by FDNS, which stands for Fraud Detection and National Security. So if you sponsor an H-1B worker, FDNS could show up at your worksite unannounced to make sure that the H-1B worker is doing what they're supposed to be doing, getting the right salary in the right place. That program exists, but we expect that it will ramp up. And also worksite investigations from the Department of Labor and perhaps worksite raids from ICE. On the employer compliance side, also mandatory E-Verify has been proposed. So E-Verify is the electronic employment eligibility verification system. Basically, every employer in the US is required to verify that their workers are authorized to work in the US, and they can right now do it in paper form or electronic form. And the paper form doesn't really have any double checking mechanism, but E-Verify will actually, go to the government database and query that the person is actually authorized to work in the US. So it has been proposed that could become mandatory. I would like to mention that actually as of yesterday, we have a new of counsel at our firm. Her name is Mary Pivick, and she is a specialist or an expert. I can't remember which word we're allowed to use under the bar rules, but she is well versed in employer compliance law. So we do, we brought her on because we do think this is going to be an area of significant focus in this administration. From the Department of Labor perspective, there are a few proposals that would impact employers. So first of all, regulations regarding independent contractors, overtime, and health and safety, I think will probably be revised in the employer's favor. So making it easier for employers to work with independent contractors, expanding the definition of independent contractors, making it easier for overtime, and maybe reducing some of the health and safety protections under current law. There are also on the DOL side changes that favor apprenticeship over formal education. So there's a proposal to create a national apprenticeship program, and a provision potentially prohibiting private employers from requiring bachelor's degrees in job postings and job advertisements unless they can document a specific need. And then the last DOL type proposal is hire American requirements. So both for federal contractors and also under current law, U.S. employers are not allowed to discriminate against workers with permanent authorization to work in the U.S. So those would be U.S. citizens, legal permanent residents, asylees, and refugees. I believe that's everyone. So what this proposal would do is allow employers to advertise that jobs are available to U.S. citizens only and not to legal permanent residents or asylees and refugees. So I will stop there and we can get to some more questions. I guess one thing I had noticed some questions, and maybe Sandra and Patrick, you can pick a question or two that you would like to address. There were quite a number of questions about, how will this impact pending applications, processing times? I would expect that all processing times will extend. There are numerous statements that the focus will be on fraud detection and vetting rather than speed of processing. So I think, to me, that's a signal that we can expect processing times to become longer really in every category and across the board. So I'll stop there. And Sandra, Patrick, would you like to pick a question or two to address?
There are so many. I hope you've been busily writing in the chat, trying to answer some of them. Let's see what else we can find. I think there's a few questions on how an individual's pending asylum could be impacted, and if there was a question in there, could I just be deported? And the answer to that is no. As Patrick mentioned, for individuals that are in the United States, they have the right to go before an immigration judge and have their asylum application heard. And the asylum law is statutory, and it's based on U.S. domestic law and on international law. So even though and there's a significant distinction between individuals that are approaching a U.S. border, say the southern border, who are trying to seek asylum but are outside of the United States, and people that are in the United States who are planning on filing asylum applications or have already filed them. So you do have that right, if you're in the U.S., to go before an immigration judge and have your asylum application heard. And Patrick, I think you would agree with me that to change the basis for establishing asylum eligibility in the United States, it would need to be an act of Congress. In order to do away, I should be more clear, to do away with the asylum laws in general, or to prohibit people from seeking asylum in the United States, would require an act of Congress.
Yes, I agree. Although it's so complicated because, like, at the border, for example, we saw that, like, Title 42, which was the public health emergency order that was announced during COVID, which apparently they're interested in sort of reviving. That disallowed people to seek asylum, but in the interior, last time they tried to pass like asylum transit bans that didn't just apply at the border. And so if you had transited through a third country and not sought asylum in that country, then you were presumptively ineligible for asylum here. And those were challenged. In fact, the Biden administration also tried to announce a similar type of rule. But yeah, I mean, it is baked into law. It is baked into our international treaty obligations and so on. But the way that I anticipate changes to asylum law happening, and we can talk about this a little bit more later, is through decisions by the Attorney General and also probably some regulatory changes that restrict who will qualify for asylum. So I think that's what we're more likely to see. I had one question that I wanted to take, if that's okay. It's somebody asked if some of us have pending cases in court and the judge is awaiting an I-130 family adjustment of status. Will Trump still go ahead and deport without a final ruling from the judge? So no, and this gets back to the issue that I mentioned before about removal being a legal process, right? There must be an order. And if you're in front of an immigration judge, you can't be deported unless that judge has issued an order and it is final, right? Final means, you either decline to appeal, or if you did appeal, and the higher court dismissed your appeal, that's when a removal order is final and when ICE can actually lawfully pick you up and remove you from the United States under that order. So if you're still awaiting a ruling from a judge, you can't just be picked up and removed. I hope that gives you, anonymous attendee who asked this question at 10:33 a.m., some comfort.
There's an interesting question here, you guys, about legislation versus executive orders, maybe versus tweets. So here's the question. With the president-elect's party controlling both chambers of Congress, do you think immigration policy will primarily be addressed through legislation, or will executive orders still continue to play a significant role?
Becky, this is a question you and I briefly talked about, right? Which I think it turns on the filibuster, really. If the Republican Senate gets rid of the filibuster, then they, will be enabled to, I think we'll have the numbers to enact statutory changes to law. But if this filibuster survives, then I think it depends on the kind of change we're talking about. I think that would mean that any changes to immigration law will be more small c conservative, right? They won't be sort of drastic changes because you're going to have to get 60 votes, which would require, I believe, 7 Democrat votes. With the way that the Senate has ultimately fallen in terms of the numbers of Republicans and Democrats. So I think the vast majority of changes, particularly the more drastic ones, will be through executive orders and through regulations promulgated by the agencies.
Okay. Patrick, I think we should move on to the second part of your presentation. And so we organized this presentation just because it made sense in my own mind about things that we might experience, new programs that would be introduced or old programs that would be reintroduced. And then in the second half of this presentation, we're going to talk about programs that we currently have that we think may be taken away. So we have a question about DACA. We have a question about TPS, so a prosecutorial discretion. So if you can make sure to touch on all 3 of those, that would be great.
Perfect. I was planning on it. Oh, yeah.
Sorry, I'm just going to make one correction to something I said previously, which is actually that special immigrant juvenile status. Someone had a question about how those types of applications may be impacted by the Trump administration, and I mentioned potentially the public charge requirement could apply to them. And actually, SIJS is exempt from public charge by statute. So if you have a special immigrant juvenile status application pending, it's unlikely that, it shouldn't at all be impacted by a new public charge rule. I wanted to clarify that. Go ahead, Patrick.
So I was going to talk a little bit about some of these programs that are likely to be taken away or changed in some dramatic way. So temporary protected status, as many of you probably know, it's a temporary immigration status that is provided to nationals of certain countries, that are experiencing some, dramatic problems, and we have determined that it's unsafe to deport their nationals back to their country. So it's like ongoing armed conflict, which is why, for example, we have TPS for Syria and Afghanistan and Ukraine. environmental disasters like earthquakes, which is why we have TPS for Haiti, extraordinary and temporary conditions in the foreign state that prevent its nationals from returning to the state in safety. That's sort of the other criteria besides the ones that I've mentioned that allow for TPS. So quite a few people are physically present in the United States in TPS. There's nearly 1 million people that now have TPS. Project 2025 calls for ending it. The last time Trump was in the White House, they did try to end it for a host of countries, but they were stymied by the courts. You know, that was a kind of common theme. There were a lot of times where courts intervened, and it's because of this law called the Administrative Procedure Act, which basically prescribes how agencies, federal agencies, are supposed to do their jobs. And you know, I suspect that the Trump administration will have learned lessons from previous, defeats that they had in court, and will kind of cross their T's and dot their I's more carefully this time when they are making the kinds of changes that we're talking about. And on top of that, you have a relatively transformed judiciary because of, the 200 and some judges that Trump appointed last time. So TPS is on the chopping block. DACA, it's a program I've worked on this for many years. So, DACA was announced in June of 2012. It stands for Deferred Action for Childhood Arrivals. It's a program that protects a group of people that are known as dreamers. These are people who were brought to the United States as children, educated here, and have basically resided here their whole lives, and are as President Obama said when he announced the program, Americans in all ways except on paper. This program currently protects some 1 million people from deportation. It has two main components to it. One is a kind of promise not to deport the person. That's deferred action. When you have deferred action, you're eligible to apply for employment authorization. So this has been, transformative in the lives of, these 800 and some thousand people who currently have DACA. Trump tried to end DACA the last time that he was president, but it kind of culminated in there was a legal battle. It went all the way up to the Supreme Court, and an opinion by Chief Justice Roberts, the court held that the manner in which they had, terminated DACA didn't comply with the law, and they kept the program in effect, although they stopped allowing initial applicants to move forward. I mean, that was something that had been in effect for quite some time. It's foreseeable that they're going to try to end DACA again. There is separately litigation that challenges the legality of the announcement of DACA. So there's an attempt to terminate it, but there was also a challenge to its original announcement that's working its way up the courts and is now awaiting a ruling from the Fifth Circuit Court of Appeals. So DACA is sort of vulnerable from two different sides. I expect that if DACA ends, it won't end like that, and everybody's employment authorization will be revoked. I think that poses a host of legal challenges that I don't think they're going to want to invite. And it will also, result in some chaos in a lot of workplaces where you suddenly have a lot of people who can't work. I think that the more likely way in which it will end is that people will get to sort of ride out their current period of deferred action as long as it lasts them. So, these DACA is granted in increments of 2 years. So if you have, a year and a half left on your work permit, that's, how long you'll have to remain in deferred action. When that program ends, similar to TPS, unless there's some ability to transition into some other legal status, you would presumably revert back to the status you had before, which is, in the case of DACA recipients, no status. The last two topics I wanted to cover, one is prosecutorial discretion. And I'm not going to go into the weeds of that. I mean, generally, prosecutorial discretion is the ability of someone who is tasked with enforcing the law to decide how and when and against whom the law is going to be enforced. The way in which I think it's going to be most impactful, prosecutorial discretion can be exercised in lots of different ways in immigration court. or an immigration enforcement. But what I think is relevant for this audience is that there's going to be a dramatic change to enforcement priorities. The last time Trump was president, within the first 2 weeks of his presidency, he announced an executive order that basically did away with any prioritization scheme and said, well, it didn't do away with it, but it basically said that anybody who is encountered in the course of immigration enforcement operations, is to be placed into removal proceedings, right? Right now, we have a prioritization system that basically tells ICE agents, look, if you run into somebody who's been here for, years and has kids and has no crimes and is just, working, leave them alone. Focus on people who have criminal convictions, who are recent arrivals. But that sort of directive is likely to go away. And, it's going to, make a lot of people, I think, who are out of status feel nervous and kind of looking over their shoulder because, that's what we saw in the last Trump administration. I expect that to kind of come back. Asylum is the other area I wanted to talk about. I think just briefly, I think they're going to try to implement fees for asylum applications, which has never been done before. They tried to do that last time, but that was blocked. They're going to try to raise the standard for what are called credible fear screenings. So right now, when somebody arrives at the border, there's an expeditious way to remove them without letting them see a judge, but there's an escape hatch from that rapid removal process where a person says, hey, I'm afraid to go back to my home country. And under current law, we give them a kind of truncated mini asylum interview. And what we're looking for there is, does this person have a credible fear of persecution in their home country, right? It's supposed to be a low bar because we don't want to send people back incorrectly. And if they pass that bar, what do they get? They don't get asylum. They get a chance to ask for asylum in front of a judge, right? But I think what they're going to do is just make it harder for people to pass credible fear screenings. They're going to probably codify some of the transit bans we talked about before, right? Where you can't qualify for asylum if you transited through a country, but you didn't seek asylum there. I think they're going to narrow who qualifies for asylum by interpreting in particular. So asylum, it's not for anybody who's afraid to go back to their home country. You have to be afraid to go back to your home country because you're going to be persecuted, which is a pretty high level of mistreatment, but persecuted because of your race, your religion, your nationality, your political opinion, or because you're a member of a particular social group. It is that last ground that the sort of Trump, I guess that Trump's policy advisors have taken the most direct aim at, because that is the ground, particular social group, that has enabled a sizable number of people from Central America who are fleeing gang violence and domestic violence to be able to prevail in asylum proceedings here in the United States. So I think we're going to see that ground interpreted very narrowly, and perhaps to even expressly exclude victims of gang violence and domestic violence. We're also going to see these asylum cooperative agreements come back into place, most likely. This was a kind of strange, I've heard it described as like a refugee roulette system where, like, if you were, seeking asylum from Honduras in the United States, you could be deported to Guatemala, where you were supposed to seek asylum there. If you were coming from Guatemala, you could be sent to El Salvador. And it was a kind of strange system that never really took effect. But basically, these were so-called safe third country agreements, where we determined that these would be safe places for people to seek asylum if they were coming in from a different place. How are they going to do all of this? They're going to try this through, third country agreements. They're going to try this through regulations, and then through what I mentioned before, attorney general decisions. With that, I'll hand it back over to you, Becky, to curate questions if there are some.
Okay, thank you. And one point I wanted to mention, there are quite a few questions about, for example, there's a question here about if a TPS holder who came legally but lost their status could change to a better status to be protected from the administration. Another question, what should institutions of higher education be thinking about for DACA students? So I guess one thing I wanted to say is that part of the reason that we have such a large population of undocumented people in this country is that for many or most of those people, there is no option to legalize their status, but that is not true for anyone. And so we often consult with individuals who have DACA status, who have TPS, and sometimes we are able to find legal solutions. There are lots of great immigration lawyers out there who can take a look and see whether there might be other options to remain here legally. So, in terms of institutions of higher education, I think, thinking about whether there's any information or guidance that you can provide your students about what might be other options. I don't think we've covered 212(d)(3) waivers, but that's worth thinking about. So especially for DACA people. So there are a variety of employment-based visas that are available. H-1B that I talked about is just one of them, but there are many visas. So if you qualify for an H-1B, let's say, but you're not here in legal status, or you don't have a status, you can't change your status to H-1B because you would have to have a status to change from. But depending on the facts of your case, you might be able to travel to your home country, apply for what's called a 212(d)(3) waiver, which basically weighs your positive equities. So, are you a member of the community, contributing to your community? You got an education here. You do, volunteer work. You're a member of a religious organization, et cetera, versus whatever negative equities you have. And then if the government wants to grant the waiver, you could come back in a legal work authorized status. So that's a very brief summary of a 212(d)(3) waiver, but that's an option that we're looking at for many TPS and DACA holders at this time. And there are other options. So anyone who has DACA or TPS and has not consulted with an immigration attorney about what other options might be available to them should definitely do so. So there was another question here. So there's a question about U4U, Uniting for Ukraine. So I want to address the second half of this question. And then maybe Sandra or Patrick, you could, let us know. I don't think that U4U has been mentioned specifically, but it is, a type of parole that could potentially be impacted. But the second half of the question is, can you change from U4U to EB2 national interest waiver? So there are two ways to sponsor yourself for a green card in the employment-based categories. One is EB1 extraordinary ability. And so that's for people who are among the handful of those at the top of the field worldwide. And the second is national interest waiver. It's a lower legal standard. It's for individuals essentially who are doing work in the US national interest. The waiting line for national interest waiver is several years long at this point. So this is one sort of common misconception that we address a lot. I think people think that they could get a green card quickly in the EB2 national interest waiver category. It will definitely take several years, probably 4 or 5 years is my best guess, but it really depends on many variables that we don't know about. So you still have, if you want to remain in the US during that period, you still have to have some way to come here. So if you're in the United States and you haven't violated your status, so you're here on a status such as TPS, let's say you came to the US and then that you qualified for TPS within a month or two of coming, you would not be eligible. I think in some cases you might actually be eligible to change your status, but even if you're not eligible to change your status, you can often return to your home country and process an immigrant visa there. So if you qualified for an EB2 national interest waiver, and if you hadn't violated your status in the US, it certainly could be possible to process that immigrant visa in your home country, understanding that it will take several years. Patrick, do you know if it is possible to adjust status? I know there's a provision that says you can adjust status if you've been inspected and admitted or paroled. Do we know if U4U would qualify as paroled under that provision of law?
Yes, it should, but there's going to be the issue of, sorry, for getting technical, 245C. And so if it's not an immediate relative, then you might have a problem. So if you're trying to get a green card, you came in on U4U and you're married to a US citizen, that should be a relatively straightforward path. If you're otherwise an immediate relative under, as that term is defined under US immigration law, and it doesn't mean what you think it means, it has a very specific meaning under immigration law, then okay. But if you were paroled in and you're trying to get a green card through employment in the United States, or you're trying to get a green card through a spouse that's a permanent resident, then I think you're going to bump into a problem, which is a section of law called 245C, which basically says such folks are ineligible for green cards if they have failed to continuously maintain lawful status since entry, and parole is not deemed a status for these purposes, just like deferred action is not a status. TPS, on the other hand, is a status. It's different. And there's special language in the TPS statute that says, if you're maintaining TPS and you sort of meet the other requirements, then you can transition from that to, an H-1B or some other non-immigrant visa, or for that matter, a green card.
Okay, thank you.
With the one, absolutely agree, and just with the one caveat that there weren't previous to the TPS status periods of unlawful presence or unauthorized employment. And this really highlights, we're giving here very sort of broad strokes immigration advice, and that's why I said at the beginning of this session that we're not intending to give legal advice on any particular case, and really a lot of these questions require a consultation with an immigration attorney.
Absolutely. And I think, we have found solutions, as have many of our colleagues in the immigration bar, for individuals with TPS and DACA. So, but immigration law is very fact specific and very case specific. So, you would need to look at your particular situation to see what's possible. I want to turn to the second part of the employment-based discussion. And again, Sandra and Patrick, feel free to answer. We have a lot of questions. We're going to do our best to get it to as many as possible. So feel free to answer them in writing while I'm talking. And then at the end, we'll cover as many additional questions as we have time to do so. In the employment-based world, we have, let's see, family sponsorship beyond the nuclear family is one thing that's on the chopping block. So how do we define nuclear family? It typically means your spouse and your minor children. Right now, under immigration law, you can also sponsor your parents, your siblings, and your adult children. And so, Sandra and Patrick, I'm curious to know whether you think all of those categories, when they say nuclear family, do they mean no sponsorship for parents, no sponsorship for siblings, and no sponsorship for adult children? Is that your interpretation?
I mean, these are categories that are built into the statute, right? The Congress has given, people a right to petition for certain family members, your siblings, if you're a US citizen, your parents, your children, et cetera, if you're a citizen or LPR, spouses. And, it would arguably defy Congress's handiwork to just, by executive fiat, take away this right. And I think that wouldn't survive legal challenge. That's my immediate take. I don't know, Sandra, if you have a different one.
I agree totally. There's some interesting case law about what the definition is of nuclear family. Query if there could be an attempt by the administration to redefine that. I think it would be difficult, though. I agree with you, Pat. There's so many other priorities that are on the table here, and taking that one away seems like a heavy lift. Although, like I said, I think the way that will be impacted will be by the slowing down of adjudications, and it could even be focused on certain geographic areas. But yeah.
Okay. So several employment-based programs that are being targeted include H-2A, which is the category for agricultural workers, H-2B, which is the category for temporary or seasonal workers. Those programs, I think, could definitely be reduced or, potentially eliminated. They're certainly of interest to the incoming administration. The Employment and Training Administration, ETA, at the Department of Labor is the part of the Department of Labor that oversees those two programs, as well as the PERM labor certification or green card program. And the administration is looking at spending reductions in many areas of the government, but specifically within the Department of Labor. That is the division that is most highly targeted for spending reductions. So I think that we can expect slowdowns in those three programs. Another issue that was identified was elimination of some EAD categories. There's no mention of which EAD categories they would like to eliminate, but if I had to speculate, I would say that the H4 EAD program would definitely be one of the first ones that they would take a look at. That has been very controversial, and I can imagine that that one is of interest. It's only available to a very limited number of H4 dependents, but I would not be surprised if that category was impacted. Biometrics reuse may go away. So for many types of immigration benefits, you don't have to repeat your fingerprints and photos. So for example, if you get a work authorization document and the fingerprints and photos are only a certain age, you don't have to go back and keep redoing them. But that was a program that was created for efficiency, and because there will be an increased focus on fraud and vetting, biometrics reuse will probably go away. The Green Card Lottery, the DV Lottery, which is a program by which we offer about 50,000 green cards each year to individuals from low immigration countries. So for example, India and China are not eligible to participate in that lottery. But the idea is to increase diversity in our immigrant population. That has definitely been targeted. And then the last item that is targeted for potential elimination is the ombudsman, which is an office within DHS that helps sort of facilitate issues when things get sort of intractably stuck. Just a few sort of general comments about overall sort of what we can expect. So we talked about an increased focus on screening, vetting, fraud detection, and enforcement, including an increased criminal enforcement component. Nearly 100% interview requirements for all appropriate cases. So for example, in most employment-based cases, you're not required, in most employment-based green card cases, you're not required to have an interview, but we may expect that that requirement could return. An agency-wide fee increase to be submitted immediately. Patrick, you mentioned a fee for asylum, dramatically limiting fee waivers. Someone asked how quickly we expect many of these changes to be implemented. And of course, we don't know, but there have been statements that they want to do as much as possible on day one. So I think that we can expect, a lot of movement on day one to the extent that it's, legally possible. And then there were just a few, two statements. One said that at least until USCIS is caught up on all case backlogs, all applicants rejected for any benefit or status adjudication should be required to leave the US immediately. Patrick, Sandra, I found that curious because as far as I know, if you are rejected for a benefit and you don't have any other underlying status under current law, you're already required to leave the US immediately. So does either one of you have any idea what they might be talking about there?
Yeah, so the policy, the Obama policy, which was rescinded in the Trump years, but then resurrected in the Biden years, on when to issue notices to appear, said that you basically, if somebody is denied a benefit and they're not otherwise an enforcement priority, don't issue them a notice to appear. In other words, don't put somebody into deportation proceedings just because they don't have status and were denied a benefit. That changed the last time Trump was president. And so if you applied for a benefit and you were, denied it and you were not in status, then you didn't just receive a denial, you'd receive in the mail also typically a notice to appear saying, hey, you need to go to immigration court, where a judge can decide whether to remove you. It's one of the reasons that the court backlog ballooned, in the Trump years.
Okay, thank you. That helps. The last sort of general point was pausing the intake of benefit applications when backlogs become excessive. That is a very interesting proposal, since many immigration lawyers might say that backlogs are already excessive and are likely to become even more extended. So, that's, who knows what that means, but it's something just to be aware of, that they are reserving the right to just sort of stop accepting new petitions or applications altogether if the backlogs are deemed excessive. So I would like to turn to some more questions. There's a good one here about parole in place. So there's been a lot of talk about that. The current administration's application for parole in place for certain non-citizen spouses and stepchildren. What do you think will happen under the Trump administration to that program?
So that was blocked by the courts. No, I mean, it took effect for like 5 days or something. I mean, it was a very short period of time before it was blocked, and I do not expect the Trump administration to revive it.
Okay. One question, so we have a number of questions from individuals who maybe have their own immigration questions, and then a number of questions from individuals like a university, or this person says they work with students and families. A majority of them have asylum status or immigrants, and they want to know how they can help those people. So aside from consulting with an immigration attorney, which I would certainly recommend to anyone who's in a position to do so, the Department of Justice at this time keeps a list of free and low-cost legal service providers. So if you Google DOJ, free and low-cost immigration legal service providers, maybe you don't need all those words, but that's usually what I type into Google. You can get to this database that has a list by state of immigration providers that will provide services at pro bono or at a reduced cost. So as you can imagine, most of those organizations are probably quite busy at the moment. So, you may have, it may be challenging to get an appointment with them, but that's definitely a resource that should be available. Sandra, other ideas about resources?
Sorry. I was just gonna highlight, Becky, that I think it's actually a really good idea to use exactly those Google words when we have a situation like this where there's a real chance of sort of fear or panic. This is when a lot of immigrants fall victims to immigration attorneys or notarios that really should not be advising them. So just a word of caution, if you are dealing with a large number of students or DACA applicants, to make sure that they are going to reputable counselors.
And I actually just put the link in the chat. So please, copy that link if you work with a population that you think could be helped by that. If you're in Washington, D.C., in the DMV, the DC Bar holds a quarterly immigration clinic. I have been volunteering there as a mentor for several years now, and it's not based on income, so anyone can attend this clinic. The way that the clinic works is that attorneys who don't necessarily practice immigration law will screen clients, vet cases with interpreters, collect the facts, and then sometimes these first-line lawyers know the solution, sometimes they don't. They will then come consult with the mentors to either say, I met with this client, here's the issue, here's what I think the solution is, or I have no idea what the solution is, can you help me? We have a group of very experienced mentors who help provide solutions, and then we either refer the clients. So it's an advice and referral clinic. It's not, you're not going to get representation at this clinic, but you will be able to get some information, maybe a referral to an appropriate organization. And so that the next clinic, the DC Bar Clinic, is going to be on the 9th of December. It's at the Carlos Rosario School. Sorry, the 7th of December. It's a Saturday. It's the Carlos Rosario School. And if I can find the link while we're talking, I can put it in the chat, and otherwise we can disseminate it later with a recording of this webinar. We have just a few minutes left. So Sandra, Patrick, maybe this is a good time for any closing thoughts, anything you think that we didn't cover that you want to mention.
I was just going to throw into the chat one other resource. This is a legal directory run by the Immigration Advocates Network. It's a nonprofit. They kind of survey the entire immigration nonprofit landscape, and they find, you can search by zip code, not just the folks who represent people in court, which is what I think the DOJ website is, but anybody that, if they provide, help getting DACA or U visas or whatever, you can find people there. But yeah, no, I don't have anything else. I hope this was helpful for folks. Sandra, did you have anything else?
No, I think we covered a lot, and I guess I would just echo some of the words that Patrick said, which is a lot of the policy initiatives that the new administration is putting out seem to disregard existing law that offers significant protections even to non-citizens in the United States. So, there's some opportunity there for there's an opportunity for due process rights. There's an opportunity for judicial review. And I noticed that a lot of the questions are, will I be deported? So again, it's not that willy-nilly they can sort of pick you up in the interior of the United States and put you on a plane. You do have a right to go before a judge. And there's also going to be significant challenges to the administration in terms of rounding up and housing millions of people. And so again, I think educating yourself on these protections is important, which is not to say that we should downplay the impact of the new administration's policies. I do think we can expect a sort of overhaul or sea change in the way that immigration policy is handled by the new administration.
Thank you, Sandra.
Yeah.
So we really appreciate everyone attending today. We do intend to present additional webinars. This was obviously a very early look at what we think might happen. Nothing is actually formalized yet. So as policies develop, as the news comes out, we will offer additional webinars. We're specifically trying to finalize one in the month of December on humanitarian issues. Today's webinar sort of covered the broad spectrum, but the December webinar will probably be more specifically focused on humanitarian issues. We also will be blogging as news develops, so please check out our blog on our website. If you're not receiving our newsletter and you would like to, we'd be happy to add you to that list, and we'll do our best to we view our role as not only as advocates, but also we want to make sure that as much correct information is out there so that people can understand what the legal situation, the legal framework, and make appropriate decisions. So thanks again to our sponsors. We are really appreciative. Thanks to everyone for attending. Have a wonderful Thanksgiving next week, and have a wonderful rest of your day.